Jay, how are you today and where are you dialing from?
Yeah, I'm absolutely fine, and I'm from India.
Thank you so much for joining my hot seat session today, where we help companies and businesses all over the world address their blind spots and gain competitive edge with the help of our wonderful mentors. I'm really excited to talk with you about intellectual property today because just before our live, I think 10 minutes before our live, I saw your post on LinkedIn where you texted something that you were driving and you saw a banner about intellectual
Yeah,
property rights and you were really excited about this. So I
yeah,
see you're really passionate about this.
yes,
Tell us a little bit more about yourself.
yeah. So first of all, I am a lovely human being, yeah, because the part of the click, and by education, I'm a pharmacist, but I'm not practicing as a pharmacist. By profession, I am an intellectual property attorney and the founder of the firm, my IP law firm, that is Excellon IP. I am a husband, I am a father, I am a brother, I am a son of my lovely joint family that we are living together here in Ahmedabad, which is in the western region of the India. And so I, in technical education, I have done the pharmacy and then diverted to the field of intellectual property because my first job was into the patent department, and I saw very good interest in the future scope of that particular field, and that's why I built a career on that particular domain. Before starting this my own IP law firm, I have worked for almost 18 years, 15 years into the this particular intellectual property, specifically into the patent department of different pharmaceutical companies. And based on all this experience, I have started this my own IP law firm.
Thank you so much. This is actually short and sweet to learn this much
Yeah.
about you. So, my first question is actually, are there any misunderstanding or even myths about intellectual property rights that you would like to address before we dive into the problem?
Yeah. So there are so many myths, and there are many things depending on the clients, their domain, their level of business they are in. There are different people, different type of people in the market. If you see, so I've generally categorized two or three category of the peoples into the market when with respect to the intellectual property. The first category is that they do not believe or think that such kind of things exist. The things like a intellectual property exist even. They do not know, right? So this is the first category. Second category is there are certain category who know that this intellectual property exists, but they don't care. They say, okay, we are doing business. I don't want IP, and I'm not afraid about the IP or intellectual property. So that is the second category. Third category is they know IP exists and they understand that okay, it is important for the business protections as well as the legal perspective and all this, but they do not want to pay money to protect it, right? They considering it as a additional cost rather than an investment. And the last and a very small category is understand about the intellectual property, its importance, its seriousness, and its growth tool for the business. And these are the category who really takes the benefit out of IP and make a very wonder into the business. Now, with respect to Meet, when we talk with the people and the clients, the very first few myths we come across related. First is that okay, I started my business, so I can do IP later. I don't want to file IP now because I have just started the business and I do not have money, or I have money but I do not want to spend on the IP. And they are having the myth that okay, I can file my IP at later stage when I will start getting some money. But that is a myth because in a intellectual property, it's a race. Whoever file first will get a IP rights. So that's the myth people are having. Second thing, people are considering that okay, doing IP or registration of the IP is a very costly affair, right? But it is not the right thing. If you have a proper strategy and proper understanding about the what kind of IP you should protect, when to protect, where to protect, and at what timeline you have to protect, you can easily consider that is not a costly affair, right? But if you do not protect, it will definitely will cost you a lot in future. right? And
Thank you.
third thing is people are having the myth is that okay, if I get the trademark, I get the global rights or the worldwide rights, or even a patent, even a copyright or a design patent or industrial design. They understand that okay, I can get the global rights, but that is not exist and that is not possible. So if you are getting the trademark for any particular country, your right is limited to that particular country only. The same way, if you want to get your trademark or the IP rights in different countries, you have to file in different countries. There is no any system or mechanism exists where you get the global rights or a global patent or a global trademark.
Mhm. I really like that you mentioned that the first thing to not be scared of intellectual property is to actually understand what forms of intellectual property exist. So could you tell me more about this and which one is applicable most to each business?
Yeah. So intellectual property is a broad subject. Under that intellectual property, there are different classifications are available, like patent, trademark, copyright, design patent or industrial design, geographical indication, trade secret, and integrated circle layout. So these are the very broad and the general classification of intellectual property. Country to country, there may be some different plus or minus, but if you consider the basics, the patent, trademark, copyright, and design patent, and the geographical indications, it will be same in almost all the countries, and all the country have this particular available registration for this IP. So now we go step by step. Okay, first is a trademark. So what you can protect under the trademark? You can protect under the trademark your brand name, your logo, your tagline, your shape of the goods. All these things you can protect under the trademark scope of the work. So either it is your brand name, product brand name, or your company name, or your tagline, or some kind of symbol, right? Even as per trademark law, the music, the jingle, the music tone can be protected. Even the smell can be protected in certain geographies, not in all the countries, but in certain countries, even the smell you can trademark, right? So these are the different types of intellectual that you can protect under the trademark. Second is a design patent or industrial designs. So it is only protecting the shape. So if you have created any particular product or an object which has an aesthetic look, which is very unique and creative in term of shape, in term of looking of that product, right? So that you can protect under the design patent or industrial design. It does not have any correlation with respect to the size, with respect to the material out of which it is made, and with respect to the what is the function of that particular product. So, as for example, you can take any furniture, any jewelry, any mobile, any gadgets. So, when someone is creating any particular gadget with a unique shape which does not exist before, then you can protect under that design patent or a industrial design. In a copyright, you can protect all your artistic, literature, music, sound, cinematography, videography, and in certain regions, even include considering specifically in India, you can protect the computer software, that's source code or the algorithm part of the software under the copyright. So any music you have created, any lyrics you have written, any painting you have done, any photography you have done, any book you have written, any article you have written, all these things you can protect under the copyright. Fourth is a patent, which is the most critical and my subject of knowledge, main expertise I have in a patent. So patent is given, or what you can protect under the patent is any kind of invention, right? Invention which fulfills three criteria: that it should be novel, inventive, and should have industrial applications. So any product or a process which you have created the first time and which does not exist anywhere into the world in any public domain, then and then only you can get the patent for that particular kind of product or a process. So there is a two different terminologies: invention and discovery. You can patent for the invention, but you cannot patent the discovery, because discovery itself say that you have discovered something which is already existing, while invention you have created something new which does not exist before, right? So all such things that you have created first time, which is not existing before in term of product or a process, you can protect it under the patent. Geographical indication is when any particular quality of any particular product is belongs to the region or the atmosphere or the weather of that particular area or a city or a countryside region, then that can be protected under the geographical indication. The example you can say the champagne. So most of the people does not know that champagne is the one of the area into the France or Europe from where the grapes are produced and from which the champagne is manufactured. So that kind of product, when the quality of that particular product belongs to that particular regions, the product's quality, then it can be protected under the geographical indication. Last is trade secret. So if you have any product which you want to keep it with you only as a trade secret and you do not want to disclose, because if you file a patent, you have to disclose all the informations. And patent has a limited life of 20 years. After that, it is open to public. Anyone can copy. But if you have trade secret, you can keep it as long as you keep it secret. But when it is leaked, it is leaked. It is open. Right. So these are the different types of uh, IP that you can protect for different kinds of business or the products you have.
Thank you. Actually, before we proceed, I see the question in chat, if you don't mind. It's from
Yeah.
Dion. She's asking, what about the Madrid Protocol? Do you know about
Yeah.
this?
Yeah. So Madrid Pro, as I mentioned, that there is no global registration or a global system exists where you can get the worldwide rights, right? So Madrid Protocol is a protocol provided for a, suppose if you want to file a trademark application in 10 countries or a 20 countries. So Madrid Protocol is providing the intermediate facility where you can file the trademark application, single application in the multiple countries in a single application. After through that application, if that individual countries do the examination and if they have any objections to the query, then you have to handle that query through the local attorney of that particular country. But if you do not get any query or the objections from the trademark office of that respective country, you can get the registration just by having your local attorney who have filed the Madrid application. And by single application, you can file the multiple countries application is a single application through Madrid protocol.
Thank you so much for such a thorough explanation of different types of patents. But let's imagine that we are talking to some business who is still very persistent and they still think that they do not need to protect their, intellectual property. What are some potential business threatening consequences that may face if they do not pay attention to intellectual property?
Yeah. So in this particular case, okay, suppose you got some idea and you are starting your company or building some product, right? Which is addressing any particular problem of the society, and to solve that particular problem, you have put all your efforts, your research, your money and times and all this, and developed a particular product, and then launch the product into the market. Now you think that okay, I don't want any IP because my product is unique and I am the first into the world to launch the particular product. You launch the product tomorrow with suppose $100 is the price. The very next week or next month, another company comes with the same product and who is selling that product in the 50 US dollar, and you are selling the $100. So now in this particular case, as you do not have any kind of IP protections, you cannot take a legal actions, and they are directly taking your market share because they are selling the same product, same quality as a half price. Why they are able to sell at a half price? Because they do not have any cost of R&D that you have spent earlier, right? There is a very first thing that if you don't have any IP protections, you cannot take legal action. There is some rules and provisions. Still, you can take the legal action, but that is a very complex and a costly affair. But if you have your IP registration in place from a day one, then you can avoid that kind of situations to be happen, which is otherwise very complex and a costly affair to stop that particular kind of competitions. Second thing is if you do not have IP, okay, I reply it in the other way. If suppose if you have a registration of IP, what kind of benefits you can take? The first is you can create a goodwill of your product and company if you have IP registration and highlighted in all your marketing materials. Second thing is you can reduce the competitions. How? you are creating the barrier by protecting your rights in terms of any IP which is applicable to your business, either it is a trademark or a patent or a copyright or a design patent. So if you have that protection, the competition will not come because you have that legal protections. And even just by mentioning that is, as I mentioned in my LinkedIn post tomorrow, it is mentioned that it is a patented product, right? So the moment I read that it's a patented product, I will not try to copy it because I know that legal consequences will be there if I do the copy of that product, right? So just by mentioning that part, you can reduce the competition at a certain level. Third thing is you can always create a valuation of your business through intellectual property, because intellectual property is also an asset which can be counted into your business valuation as an intangible asset part. Another thing is it can differentiate yourself from the competitors who are into the same kind of products. It also gives you an added advantage of the bargaining power. Suppose if any other company want to be associated with you, either for the licensing, for the joint venture, or any kind of collaborations, if you do not have any kind of IP registrations, you will definitely agree what are the terms they offers, terms and conditions, and the money they offers. But if you have all your IP protected, registered, you can use your bargaining power. That okay, for this particular product, only we can supply you this product because we have all IP rights with us. So, but so we want to make a deal with this particular amount and with this terms and condition. So, if you have IP registration, you can use the bargaining power over there. And second thing is litigations. You can also use as a defense strategy. Although you don't want to take a litigation to someone else, but if suppose in future someone's initiate the litigation against you, then if you have IP registration, you can use that as a defense that okay, we already have our IP registration in place from this particular date. So these are the different things one can use as a benefit, and if they do not protect, other will be the consequences they need to face in the business sooner or later into the business.
Oh, this is so much of information. I feel like most of business owners, I'm getting overwhelmed with how much is out there and how much I need to
Yeah.
protect. But let's calm them down and mention, what are some strategies and maybe even secrets that you can share, for businesses who are looking to proactively protect their intellectual property. What can they do?
Yeah. So as I mentioned that it's a race, whoever file first will get IP. So the moment you are working on something, either it's an idea or concept or a startup or existing business, and you're adding or developing a new product for your portfolio, the moment you have some clarity about it, do it and file. File the brand name, file the patent, file the copyright, file the design, whatever applicable as per your business and the product. So that is a very, very critical, because okay, sometimes what people think is that okay, they are developing some product and they think that okay, once my product is ready, I will file the patent. But the moment, suppose their development is taking 3 months to 6 months, and they are waiting their product to be ready before filing the patent. So now in between this timeline, if someone else file the patent in other part of the country, then you are losing your priority date because he has filed first.
This
So
is a
the
great
second,
point.
yeah. So the first thing is that okay, as he has filed first, you will not get the patent because you are second and you are filing after that. That is the first thing. So you will not able to protect the patent for which you have initiated first. Second thing, if suppose that person got the patent registered in future, then he may create litigation or legal actions against your business also. Right. So that's the reason file your applications as early as possible once you are clarity about your product or a business. Second thing is always and always take a expert help. Definitely you can basic, there are resources are available on the internet. You can understand the basics about all these things, but at the time of filing, always and always ask for the consultant who are the professional and expert in this particular domain. Third thing is define the IP strategy. Each business have their HR strategy, their business strategy, their marketing strategy, their sales strategy, but most of the people are ignoring the IP strategy. And that IP strategy should be customized and defined as per your business, as per your vision, as per your mission, as per your goal, as per your product, and as per your market country of interest. Because even in the same business, same product, but two different companies with a two different vision, goal, and objective have a different IP strategy. So the very critical is that you define your IP strategy, which is in alignment to your business strategy and marketing strategy, and execute it like way. And don't consider it as an expense. Consider it as an investment. It will definitely give you benefit in the future.
Thank you. I think actually your last answer, made me relieved because I'm not scared of protecting my intellectual property anymore. If I was to have my own business. So thank you so much for sharing all of this information with me. I feel like I haven't intaken this much information in any of my LinkedIn lives. So I really appreciate it, and I'm sure our audience did as well. So if you do, I highly encourage you to check the caption and see how you can work with Sanjay and his company to solve your intellectual property problems. Again, thank you, Sanjay, and I hope to see you thriving in our mentor community.
Yeah, thank you, Kate, and thank you, Glick, for providing this platform to express or exchange my knowledge, which will, I hope, at least one person will get some information and help in their business.
Oh, I'm sure they will. I'm sure they will. Thank you.
Yeah, thank you.